today we are talking Parliament. We are talking about the Supreme Court ruling on Parliament. We are talking about the Speaker's decision to adjourn the sittings of Parliament indefinitely. We are talking about the move by some in the minority, well, they still insist that they're the majority, to recall Parliament. Where is all of this taking us? And indeed, we are very privileged to have a very articulate member of Parliament, one of the young and very articulate people in Parliament, to be with us today to discuss these issues. It is indeed our pleasure to have in the studio Honorable Kofi Adams, Member of Parliament for the Buem constituency. Honorable, you're welcome to the studio.
Thank you, comrade. Thank you so much for the opportunity, and thanks for inviting me to this great platform.
Yeah. Well, first of all, give us a general idea of what is happening in Parliament. What is it that is happening in Parliament? What are the issues?
Well, the issues are what you expect to happen. We are engaged in constitutional democracy. Our Parliament is about 32 years old now, at least for this Fourth Republic. And this is the 8th Parliament. And this Parliament is lucky to have as its Speaker one of its own that started with the Fourth Republican Parliament. That's from 1993. He's been in the Parliament, and so he's been part and parcel of the building processes of what has become as a practice of Parliament today. The standing orders that we recently jettisoned, which was passed somewhere in the year 2000, he was part and parcel of that process. And the current one that we are working with, he's been part and parcel of seeing it through. And so I can say that we have a Speaker who has seen everything about Parliament. And so we've been guided by this Speaker with his experience. This Parliament is also unique in the sense that the two parties that find themselves in Parliament today have equal numbers. We've had instances where only two parties have been in Parliament also, like we had in the 7th Parliament, the NDC and the NPP. But the difference in the 7th Parliament and the 8th Parliament is that the NPP, which was the governing party, had a huge majority, 169, and the NDC had only 106. Today's Parliament is equal in numbers. And on the 10th of January 2021, the Speaker gave a ruling which gave the NPP side of Parliament and described them as majority group, because he could not have described them as majority caucus, because they were not, if you use the term caucus, they could not be described as majority. Because our standing orders defines what a caucus is. It says a party or parties. So it is not the independent member cannot join a group to form a caucus. So Mr. Speaker, because under Standing Order 5 is given the mandate to interpret the standing orders, and where there is no particular provision, he is to make supplementary provisions as he deems fit. So on the occasion when he ruled and described them as a majority group because the independent chose to do business with them, we accepted the ruling of Mr. Speaker based on our constitution that mandates him, that gives power to him to interpret our standing orders anytime there is any confusion or there is no provision for a situation that arises. So our 137 was described as the minority group. So a new coinage was introduced: majority group and minority group. Even though we were not a group, we were a caucus because we were one full party. They could be described as a group. We've been working with that. Then the electioneering period came in. Some members went through the processes as enshrined by the various political parties, and for whatever reason they did not make it in the primaries, and they gave indication that they were going to represent their constituents as independent members of what? Parliament. But you can't base on just radio report or news report to take anybody on. There need to be an evidence. So we have all been waiting, thinking that it's part of maybe what we describe as political talk, and there was no evidence, even though the statements came from many of them directly. Well, the Electoral Commission opened the nominations, and various persons of interest filed both for presidential and parliamentary. We were still waiting and waiting. The Electoral Commission now issued what we describe as notice of polls, because that also goes through a gazette process. And we found out that 3 members of parliament who were elected on political party tickets, one on the ticket of National Democratic Congress for Amenfi Central, Honorable Kwachiaka, has picked from field and has appeared on the notice of polls as an independent candidate for the same constituency that he has been elected as a member on the ticket of National Democratic Congress, when the National Democratic Congress also have a candidate in that particular constituency. Again, we saw another notice of polls from Agona West with a candidate going for independent in the name of Mamile Morrison Cynthia, who has been elected to represent that very constituency as an NPP member of parliament, now going independent. Then the third person was from Suhum constituency, Honorable Kojo Asante, who has also filed to contest as independent, though he's been elected to represent that very constituency as an NPP member of parliament. The fourth one was the independent member of parliament for Mina, who also doubles as our second deputy speaker, who has also picked form to contest as a member of parliament representing the NPP. So this notice of polls now moved the conversation from hearsay to an fact-based evidence. 2 members of parliament triggered the process. One chose the option of a petition. Honorable Haruna Idrisu said he was going to petition Mr. Speaker. And when a petition is invoked, it has its processes that it goes through. Another member of parliament, who was until recently the minority leader, now majority leader, and the member of parliament for Ejumako Enyanisiam, chose the option of a statement and an agent one. On the leave of Mr. Speaker, you can make a statement under Standing Orders 93. So he came through Standing Order 93, made a statement, and that statement, you allow members to comment, including the affected members. So when I hear people say hearing was not given to affected person, that is not true. Because when a statement is made, every member has a right to comment. Indeed, when a statement affects you and you have commented on it, and in the course of somebody's comment, he makes a comment that affects you directly, with the leave of Mr. Speaker, you can be given opportunity to even come back, even though our standing orders do not allow double contribution to a statement. But if it affects you and concerns you directly, and you are on your feet, and you convince Mr. Speaker, you are given the opportunity to speak. But all these 4 members, because they knew what it is that they have done, and they know the constitutional ramification and implications, themselves chose not to be present or even not to comment on the statement. But many other persons commented on the statement, and Mr. Speaker listened to all the comments and gave indication that he was going to read thoroughly and come out with his reasoned judgment, in other words, decision on the statement. We have also adopted a system that we put in place now, declaring Thursdays as decision days. So there are days when we set aside for all matters that have transpired in the week to be decided upon. So on Thursday the 17th, Mr. Speaker came and, having gone through all the processes, delivered his decision on the statement made by the then minority leader on the 15th of October. And to his clear understanding and explanation, those 4 members of Parliament, based on the notice of post and based on the constitutional provisions, Article 97, 1, G and H, have lost their status as members of Parliament. So Mr. Speaker went ahead and so declared the seats as vacant. And
can we go back to January 10th, 2021?
Yeah.
Why should we always look at Parliament as majority versus minority? Is it necessary?
Well, from what we inherited, the majority side sits to the right of Mr. Speaker, and the minority side sits to the left. And so in terms of sitting, there must be a definition as to who is majority and who is minority.
Even when there's no majority?
Well, even when there is, there must be understanding. There must be some understanding.
Because it is possible to have a situation where there's no majority.
That's true. That's true.
As in this case.
As in this case.
So why should people necessarily sit on majority and minority sides when there's no majority, strictly speaking?
So that is why the standing orders made some provision for Mr. Speaker to give direction where there is no provision for a situation that arises. So on this occasion, the very Speaker that venom is being poured on today chose to add the independent who gave indication about his desire to cooperate with the NPP side as adding him and introducing a new terminology, a majority group. It could have been contested.
But strictly speaking,
yes,
if you look at Article 97 G or H.
1G, 1H.
1H.
Yeah.
The independent could not have declared to work with NPP. It's an infraction of the Constitution.
That you are right to a very large extent, that because he came in as independent, and therefore he should keep his independent status for the entire 4-year period.
Exactly.
And you could vote along with them anytime they are voting that maybe you are independent, but on this issue you agree with them.
Yes.
And you are right to agree with them on every issue.
Yes.
As independent, but not to declare. So that was why Mr. Speaker was smart not to describe them as a majority caucus.
Wouldn't the Speaker have been smarter if the standing orders had been changed to suit a situation where there's no majority and where there's no minority?
Well, now with the new standing orders, something like that have been done, but it's still not clear. So when we were even considering these new standing orders, I raised that issue based on the decision of Mr. Speaker of this majority group and the minority group definition, and indicated that if you look at the interpretation column of the standing orders, we have not made provision for a description of a side as a group. What we still have is majority caucus and minority caucus, but now we have introduced independent caucus, where if we have a minimum of 7 independent members, they can constitute an independent caucus. But if you have less than that, it means they may have to kind of affiliate. But if they are going to affiliate, the standing orders still did not make provision for the group description, even the current one. But the current standing orders...
Why can't 2 independent MPs form an independent caucus?
Well, it's our practice and procedure says you must be a minimum of 7. That's what it says, that a minimum of 7. So we must get at least 7 or more to have an independent caucus, and that is what we have approved. And the Constitution, Article 110, gives us that mandate to develop our standing orders, which we have done, and that is what is in it. And we didn't have a contest. We had one independent member. I thought that he should have fought that no, the 7 is too high, and that room should be created for even one to stand alone. And that it is because there was no such provision. That was why I have to even join one of the groups. But we didn't get that fight from the independent. If we didn't have an independent at all, I would have said, well, there was no independent member to fight for independent. And because for us, the political party reps, we don't want a situation of encouraging party members leaving and going to contest independence. So I will not be the one who will be fighting to create room for people to go independent and come and form caucuses easily in Parliament. So maybe the political parties, we were selfish. And the independent member, the formula member who was part of us, didn't also see anything wrong with saying that a minimum of 7 is what could form an independent caucus. And so that is what is in our standing orders currently.
But Honorable, beyond the Speaker, is there any other authority which can declare a seat in Parliament vacant?
Yeah, beyond, there is a provision in the Constitution, 92 Constitution, Article 99, that gives also some power to a high court. They can also declare seats vacant, or they are given the mandate to determine whether a member of Parliament was validly elected. Is the High Court. So matters of parliamentary elections are determined by the High Court, except that the decision of the High Court can be appealed all the way to the highest court. But you commence that process only at the High Court. So Article 99 makes provision for a High Court to determine whether a member of Parliament was validly elected, or upon any other occurrence after the person was validly elected, his seat could be declared as what? Vacant. But you will have Article 97, 1 and 2, which also deals with tenure of a member. And in Article 97 are defined when a member's tenure could be terminated. Either that member gets elected as a speaker, like Speaker Jaho. Speaker Jaho was elected as a member of Parliament before he got elected as Speaker. So on that occasion, he has to vacate his seat as a member of Parliament. So he was elected. You can't be a member of Parliament and still be the Speaker of the House. So if you get elected as Speaker, you have to vacate your seat. If you cross carpet, like in the case that have happened to these 3 members, you have to also vacate your seat. If you were elected independent and you join a political party, you have to vacate your seat. If you resign, you have to vacate your seat. So there are instances that could bring your tenure to an end is found in 97. Then instances where a court can pronounce upon the validity of your election or the vacancy of your seat is found in 99. So both have the powers, except that both in 99 and 97 the Speaker has to communicate to the House. Under 97 it doesn't have to go to court.
Yes, but under 99, all that the court does is to decide that we are validly or invalidly elected.
Yeah.
Okay.
That's what it does.
In 97, it deals with vacation. You could have been validly elected.
But your tenure.
But your tenure comes to an end because of some. So the two are different.
They are completely different.
Okay.
They are completely different. So when I hear people argue that, oh no, the whole process should have been under 99, and that the Speaker had no business and no power to determine, then why is 97 there?
But even previous speakers have taken side decisions. And as far as I know, all vacancies have been declared by speakers.
Exactly.
You know.
Exactly.
Except in the case of the Chikwesin.
Yeah, where the court declared. But even that one, the Speaker did announce.
Yes.
Even that one, the Speaker did announce.
Yes.
And that was what triggered the
Speaker who made the final,
declaration, the announcement. And then the Electoral Commission now took steps to make sure that the by-election was then organized. So in all situations, in the instance of 97, the previous Speaker, not the first Parliament, not the second, not the third, not the fourth, not the fifth, not the sixth, just the seventh, the yesterday Parliament, utilized 97. Utilized 97G.
In the case of Formina.
In the case of Formina. The same Formina today that is also suffering under H. Just the yesterday Parliament, the Speaker Michael Kwe utilized 97. And the very people who are so unhappy today were so happy and celebrated it, because then it didn't affect their status as a group.
There's something very interesting about Article 99 of the Constitution, okay, which vests the power to determine the validity of the election of a member of Parliament. Okay. Now, if you read Article 99 carefully, it says that if you are aggrieved by the decision of the court, of the High Court, you can appeal to the Court of Appeal. Supreme Court is not mentioned.
It's not mentioned.
And in fact, there's a Supreme Court decision which says that the Supreme Court is stopped from making declarations about validity of elections and so on.
Parliamentary elections.
Elections.
Yes.
Doesn't that sound a bit strange to you, given what the Supreme Court is doing now?
Well, very strange. And it's so strange to even many practitioners of law and teachers of law. So right now they are even wondering what they should be teaching their students, because this Supreme Court is creating very serious problems for them. Things they have taught their students, things they have used in practice. And so some of them are being forced now to speak out because they don't want to be added to this troubling development from our Supreme Court. I was on a program with someone yesterday who said because Supreme Court has the power of interpretation, So it is the best brains that are put there. No, that are put there. So I said, well, I doubt if what is coming out now, we can clearly say that we have put the best brains there. Unless the brains are there, but they choose to use the brains in another way, other than how we know how best brains are used for. Because they are confusing students of law and law lecturers and practitioners of law. That's what is happening. And we are so worried. And no wonder one of the former Chief Justices has made a statement that I read online, that our Supreme Court, the level of predictability of our Supreme Court today is almost 100%. It's more like you will not lose if it's a bet. This current Supreme Court, just know the matter and get to know who the plaintiffs are, and you can tell the outcome. And that is dangerous for our democracy, and it's dangerous for building our law, and nobody will be happy about what it is that the Supreme Court is currently engaged in. It's bad for us, and it's not the way